Thank you, Mr. Chairman. Treasurer Reese, thank you for coming before us, and I applaud your staff. They've been great to work with, answering questions through a very, very tough time. So I appreciate Christopher and Keith and all their work and openness and help along the way. First, Federal Labor Standards Act. There's some exceptions to that act. Can you just give us what those exceptions are to the Federal Labor Standards Act?
I think it's best for my counsel to
Yep.
do that. So, Christopher?
As the statute provides, exceptions involve individuals that are elected to office, individuals that are the personal staff of electors, and legislative librarians were carved out. I mean, are covered, but everybody else in the legislature is not. People that give legal advice to elected officials. That's a summary.
That's it for the exceptions.
I'm not telling you that's definitive, but those are the big exceptions.
When the administration sent you payments during the impasse, did they use a broad definition of employees, or did they also cover what those exceptions would be to Federal Labor Standards Act?
When we met with staff with the administration, we came to the conclusion that while there were employees that would not be covered by Fair Labor Standards Act, there was other legal authority upon which to pay those non-covered employees.
Okay. At some point, can you provide the committee those standards that were set up during that time frame so we know?
What we have is a legal memorandum delineating those legal authorities that was written within the context of paying the General Assembly. Staff and members.
Okay.
If I have not already done so, I will provide that.
Okay.
copy.
I wasn't sure if I was looking more broad-based with the overall administration, not just what transpired between the General Assembly and the Treasury.
It would be applicable to the executive and the judicial branches.
Okay. Under the gasoline taxes and motor licensing fund restricted account in the Constitution, there's a provision that allows borrowing from that fund, and that limitation is 1 year. I want to make sure I read it right. No loan shall be made within the period of 1 year from any preceding loan. There is a large amount of impasse spending that was pulled from the motor licensing fund. If an impasse happens again, are those same loans available from the motor licensing fund based on that provision? Or are there going to be another pool of money that the administration will have to look for, the budget secretary will have to request from the treasurer's office to find where that money goes?
I think you're talking to Representative Seth to the where we draw the funds to be able to pay in to make those loans. I can get more brief to the process that we take to identify the sources and how we provide the money for those loans.
I know there was a memorandum from the budget secretary to the Treasury outlining where they wanted everything paid. I wasn't sure at what point does that provision kick in? Was it from the initiating date of the loan, when it was fully executed, what time frame? You probably don't have an answer now, so please feel free to get back to me on that one. With corrections, the General Counsel sent a memo outlining the constitutional arguments to pay corrections during an impasse. And they are rooted in the Supremacy Clause of the United States Constitution, ensuring that prisoners meet health and safety requirements. Obviously, they need to have maintenance moving forward. Now, since the governor is declaring that the correction budget is constitutionally protected, is it possible to even veto that line item any further? Can the governor do a full veto or a partial veto of a constitutionally protected line item that the administration is making?
That's a legal question and constitutional question.
In theory, he could completely eliminate the Department of Corrections so long as there was an alternative way of feeding, housing, sheltering, and caring for inmates and protecting the general population from those that have been deemed dangerous. The current veto, as it takes effect now, puts Treasury in the position of ensuring that those operating expenses that we may pay for are strictly related to those services that are critically necessary, and that would not otherwise cover services or costs that were deferrable or otherwise discretionary.
I get that and understand that. But wouldn't that make the governor's even veto null and void? I mean, it almost seems like he overrid his veto by having it paid for, and I get the reasons why he's paying for it. But if you know it's constitutionally protected, why go through the process of making that veto to begin with? And it provides that constitution, like who can override that veto? And it seems like he literally overrid his own veto.
I understand that concern. I would just suggest that it's not Treasury's role to determine the wisdom of a veto. We just deal with the aftermath.
Let's say the administration would ask you to make a payment to school districts. We just saw that Steelton is looking at trying to get bonding to get through. Let's say they're looking at closing down. They have federal mandates they need to abide by. They have to provide for school lunch. They have to provide for special education. There's a lot of federal guidelines that base school districts have to abide by. If the administration sent a request for payment for basic education funding for those school districts so they don't close down to meet those federal guidelines, is that criteria to make payments for school districts? And I get we're in a tough spot, but these are legitimate concerns that may or may not be coming up.
Right. No, I was thinking this, thank you, Christopher. That's where the lawsuit is right now regarding school district payments, because we were sued to not make any payments until ruled.
Okay. All right. I appreciate that. And again, there's a lot of gray area. There's a lot of questions. What is a veto anymore? Is the governor overriding his veto when obviously there was no movement from the General Assembly to override a veto? And I understand you're in very, very tough predicament of making some tough calls. And a lot of it, I think, has to come on from what the administration is demanding the decisions that you make, which I think is very unfair to you and your staff moving forward. Generally, over the impasse, the administration, I think it was just reported in the news recently, that the administration has spent roughly about $50 billion. Now, that's federal, state dollars, all in, for this half of a year. During that same time frame, or for the entire fiscal year that Governor Corbett was in office, he spent about $99 billion, all in, 14-15. Is there a risk based on that half a year spending that we exceed Governor Corbett's spending, even without certain line items not being funded? And at what point does the Treasury look at kind of drawing a line on you're exceeding your appropriations limits?
I think that's a question that I would look at and say, what portion of our spend is related to salaries, benefits? I mean, that is a huge portion of our dollar spend, and that's why you see such a high number, is that when you pay salaries, benefits, and other related items, it's not uncommon for that to be 60-70% of your payroll, if you will. And so that's a huge spend. What would the total amount, what would be the final amount? I don't know. But as you have seen, a large amount of that $44 billion is really federal and other related special one-time payments that had to be made.
Who's in charge of reconciling the impasse payments, the loans from motor licensing fund, any kind of waiver money coming out? Is that the budget office, or is that Treasury who unwinds that money within each department's appropriation?
I would believe that would be a combination of both, because the budget office one, it tells us what needs to be paid, and we review payments.
Has the budget office asked you to reconcile those payments as of yet? Are you aware?
As the treasurer said, it's a mix. We wouldn't do the reconciling. That's not our job.
Okay.
The Office of Budget proposes a variety of expenditure adjustments, journal entries, and other general ledger kinds of activities in order to reconcile back what are called Ledger 5 expenditures once the general appropriation budget is passed. We review those when they're proposed, but we do not originate the reconciliation activity.
Okay.
As part of the fiscal review lawful and correct process.
Correct. And then with the purchase cards, that law change was taken away, and I think you hit that earlier, that you see the aftermath of the payments. It's really up to the administration to kind of, at this point, self-police, and just for the general public, the purchase card is a credit card each department has, and they're supposed to use it for toilet paper, pens, pencils, those kind of issues. Is there any limitations on the purchase cards for use at all?
Yes.
Yes.
Yeah. The purchase card is, in fact, regulated by a policy that the Office of Administration establishes. It is, in general, purchase cards are to be used for certain kinds of purchases where it is more efficient to pay through that mechanism than through a traditional purchase order or field limited request or things of that sort. There are also obviously credit limits that are associated with the purchase card.
When the administration sends over payment requests, do they send over analysis of where they are at within those appropriations? Let's say the administration, or we appropriated within a budget $1 million for a line item. Does the administration come back and say, we've spent $900,000 is what we spent it on, we still have $100,000 left, and here's the payment? Do they supply where they're at on the appropriations for that?
Well, again, that would be
We're tracking that on our own. I mean,
Okay.
we think of ourselves as the book of record for those kinds of things. So we're maintaining a status of appropriations on an instantaneous basis. In fact, at this point, the Treasury website, I believe, has daily postings of the status of appropriation, so anyone can confirm how much money has been charged back against an appropriation at any point.
If a department sends in an overage, what happens to that overage? Denied? Do they run it as a deficit for next budget year? How is that reconciled?
If they propose debiting against an appropriation whose funds have been completely exhausted, the payment is blocked.
Yeah.
Okay, so they can't make those payments. If it's for personnel, it would fall under Salaries and Benefits, Federal Labor Standards Act. So if the governor would enter into a contract with state employees and that contract is exceeded the amount that's appropriated by the General Assembly, would literally add to the structural deficit because money wouldn't be available. We would still have to pay that money out.
I'm not sure that I agree that that constitutes a structural deficit. That constitutes an expenditure that exceeds the appropriation for that particular line, but it is, in fact, if it's a Fair Labor Standards Act situation or other federally mandated payment, it is a payment that we would nonetheless make. That's correct.
Okay.
I mean, again, just to go back to what the Treasurer said multiple times, we need a demonstration that the payment appears to be lawful and correct. There's certainly some that are recurring, and we understand what the legal rationale is. When we encounter something that we have not seen before, we ask for both legal and other practical supporting justifications.
Okay. Thank you. Thank you, Mr. Chairman. Again, thank you for being that independent voice. Thank you.